Hello, everyone, and welcome to TCC Connect's celebration of Constitution Day. Thank you all for making the time to join us today. Before we start, I'm just going to ask that you turn off your cameras and you mute your mics, just so we don't get a lot of feedback noise. You should be able to use the chat function. So as the speakers present, feel free to type questions, chat with fellow students. I'll be monitoring that chat. So if you have questions, go ahead and type them there, and I'll make sure the speakers answer them with the Q&A at the end. At the end of the presentation, I'll share the link so that you can get attendance credit, and then we send the copy of that attendance out to your professors to let them know if you were here, if they're offering credit or extra credit. So my name is Misty Wilson-Mehrtens. I'm the chair of social sciences at TCC Connect, and I teach history. And before we start, I just wanted to give you guys a little bit about why we are celebrating Constitution Day today. As I'm sure most of you probably know, the Constitution was signed on September 17th, 1787. And then we didn't really have a celebration of that day for quite a while. In 1940, Congress is going to designate the third Sunday in May as I Am an American Day. That's not a super catchy title, never really caught on. So in 1952, an Ohio woman named Olga Weber is going to petition the state of Ohio to change I Am an American Day to September 17th, so it coincides with the signing of the Constitution. Ohio is the first state to celebrate Constitution Day in that way. It's a success. So other states are going to start adopting that. And then a little bit later in the 1950s, Eisenhower is going to sign a bill that makes I Am an American Day into Citizenship Day, but celebrated on September 17th. Fast forward to 1997, and Louis Lay is going to be taking a course in the Constitution from the Constitutional History Center. And she just really develops this love for the Constitution from there. So she's going to found a nonprofit called Constitution Day Incorporated, and she petitions lawmakers to recognize Constitution Day, which is now why we have this specific holiday celebrated in every institution that gets federal funding. So we are here today to honor the Constitution, and we have those two women to thank for getting us to this point. But this also marks the 100th year anniversary of women having the right to vote. So all of our speakers today are going to be talking to us about women and their interaction with the Constitution. So first, we're going to hear from Professor Kimberly Cox, who's going to talk to us about the path from Seneca Falls to the 19th Amendment. And then we're going to hear from Rebekah Pointer Adderley, who is going to talk to us about the early civil rights movements. Kenya Wilson is going to talk about the later and continuing civil rights movements. And then Professor Davis Hanna is going to get us to women in the Supreme Court. So at this point, I'm going to go ahead and hand this off to our first speaker, Professor Cox.
Hi, good afternoon and welcome to Constitution Day. And I'm sorry, Misty, this is the first time I've done, there we go, make the slides go forward, there we go. Sorry about that. So I'm going to do the path from Seneca Falls to the 19th Amendment, and I think the foundation of our democracy is really rooted in the right of all citizens to express their opinions and to influence their government through their vote. And I also believe this is core to the idea of we the people. However, when you look at this, the path to full citizenship has been long and arduous for many groups. And for example, it will take women over 70 years and 3 generations of hard work, dedication, and a lot of failures to really realize their full citizenship through the adoption of the 19th Amendment. So my first question is, did women care before Seneca Falls? Because obviously Seneca Falls comes much later than the founding of our country. And the quick answer is, of course they did. An example is the Grimke sisters. They grew up in South Carolina and made their way to New York as adults to work with the abolitionist movement. And they were often found writing and speaking out about the evils of slavery, only to be told that women should not be speakers or hold leadership positions within the abolitionist movement. And the fervor they raised about the women question caused great dissent within the abolitionist movement. movement. And I mentioned the Grimke sisters specifically because they're good friends with Elizabeth Cady Stanton and her husband, who I'll talk about next. And in doing putting this together, there seems to be this connection and a handing of the torch as one looks at women's history and the struggle for voting equality. And I think they also illustrate the frustration many women had in working with men's groups. And basically those groups are the abolitionist groups' aversion to fully supporting women's rights. And we'll continue to see this as a wedge as women split off from the abolitionist movement and form their own movements, their own women's movements. So Seneca Falls is in July 19th to 20th in 1848, and the key women are Elizabeth Cady Stanton and Lucretia Mott. Both were involved in the abolitionist movement. In fact, just after Stanton's marriage, she and her husband traveled to London to attend the World Anti-Slavery Convention in 1840. Women at this convention are barred from sitting on the convention floor due to their gender. They're required to actually sit at the back behind a screen so they can't even be seen. Mott is present at this convention. This is where she and Stanton meet. And as a whole, the women at this London convention are outraged by their treatment. Or remember, this is a catalyst for change in starting a women's movement. So 8 years later, when both women are back in the United States, Mott actually invites Stanton over to her house to speak with a group of people about putting together basically a plan of attack on how they're going to approach women's issues. They, in that afternoon, decide they're going to have a convention that's going to be held only 5 days later. And they expect about 50 people to attend, but between 200 and 300 actually show up, men and women. It is the first women's rights convention in the U.S. and the first public proclamation on women's rights to vote in the U.S. Their purpose is to discuss the social, civil, and religious conditions and rights of women. And what they present is this document called the Declaration of Sentiments and Grievances, and it presents 16 resolutions. All of these resolutions pass, and all but one unanimously. The one that's most controversial is the right to vote, women's suffrage. And I think that at that point you have men like Frederick Douglass, for example, who will stand up and say, hey, this is a good idea. We should support women's suffrage. The result is the resolutions given will set the agenda for activism for decades to come for women. And it'll also set a tradition for conventions to meet, discuss, and organize women's rights. So really quick before I move on, I wanted to talk about these two pictures. The top one is a depiction of what it really looked like at Seneca Falls. And I love this bottom picture. It is a satire. It's described, if you look back at it, as the four horses of the apocalypse and the end of days. You see women riding astride, wearing inappropriate clothing at the time, showing an ankle, a knee, oh my. And I think that this is kind of depicting how most people felt about women and women's rights, and they're asking for them. So as we move forward, what about as the Civil War closes, and are women going to be added to the Constitution? A petition for universal suffrage is presented to the Joint Commission on Reconstruction in Congress at this point by Stanton, Susan B. Anthony, and other activists. They had actually received a copy of the proposed amendment, the 14th Amendment, from a supporter in Congress, but after reading it, they were afraid that women would be left out. Women were not mentioned, and they were afraid that they would be thwarted by a declaration that only men could vote. What did they say in this declaration? The undersigned women of the United States respectfully ask an amendment of the Constitution that shall prohibit the several states from disenfranchising any of their citizens on the ground of sex. That's the general gist of it. And so as they present this in Congress, they get an answer. And I think that the answer given by Senator Jacob Howard of Michigan really sums up how men felt about women getting the vote at the time. He says, by law, women and children were not regarded as the equals of men. Mature manhood is the representative type of the human race. And I think basically it kind of sets a tone for how women are viewed. Again, the mention of comparing women to children is really important. This also is the first national petition drive that features women among its demands in the U.S. Stanton, after seeing that women are not going to be included in the 14th Amendment, later the 15th Amendment, I have this quote. Oops, sorry, it didn't move forward. Oops, it's not moving forward. I apologize, Misty. It's not moving forward. I'm going to take control again and see if it will. It is stuck. I apologize. Can you hear me, Misty?
I can. I'll try to move it forward for you.
Thank you. I'm so sorry.
Okay, it looks like it moved forward on my end.
It's not on mine. Let me see if I can. And I do apologize. I might have still stuck on adding suffrage after the Civil War. You may try to take back. I apologize.
If you want to.
Yeah, it's still not letting me, and I apologize, you guys.
If you want to keep going, I'll just try
Okay.
to match pace with you.
Okay, sure. Go to slide 5 on Stanton's comments. Sorry. Next one. Okay,
Got it.
So got it. So basically on this particular slide, I'm going to skip, and I apologize to conserve time too, to the underlined portion. What Stanton says in this quote is the only way they could open the constitutional door just wide enough to let the black man pass in was to introduce the word male into the national constitution. And what had actually happened here is the Republican Party had come to the women's movement and said, we can't do both. We can't do both black male suffrage and women's suffrage. The nation just can't handle it. So what was Stanton talking about? On the slide that's going to come up, you'll see the 14th and 15th Amendments. And in Section 1 of the 14th Amendment, women have hope because it doesn't specify gender. If you look at the highlighted portions, it only refers to citizens. However, in Section 2, and this is on purpose, male is added to specify which gender. So you'll see male, male, male. There's 3 places. Also, as the 15th Amendment is added, they think, okay, maybe this is a chance to clarify, but you'll see that gender is purposely left out of the 15th Amendment as well. This is really one of the last straws for women, kind of coordinating with the abolitionist movement and trying to get the women's suffrage movement moving forward. And so what they'll do at this point, and what's significant, is they'll break off and form their own women's groups. So on the next slide, Truth and Anthony, women don't just give up, but remain persistent in the cause. In 1872, we have a presidential election. It's Ulysses S. Grant is running for a second term of office under the Republican Party label. And Susan B. Anthony and Sojourner Truth and dozens of others, women across the country, actually go vote or try to register to vote in this election. Anthony and her sisters, her 2 sisters, cast their vote in New York and are arrested 2 weeks later. And if you get a chance to look at that case ever, it is really interesting. And I love the letter here, which you guys can read, which Anthony sent to Stanton. It really kind of shows her joy in being able to go vote and get it done. Sojourner Truth appears at polling location in Michigan, demanding her vote, but is turned away. And the argument that all these women will use at this point is that they are citizens and they deserve equal protection of the laws under the 14th Amendment. Also, Susan B. Anthony hopes to use her case as a test case to go to the United States Supreme Court, but she doesn't make it past the state court. On the next slide, Minor versus Happersett. This is the case that does make it up to the U.S. Supreme Court. Virginia Minor attempts to register in Missouri, but she's refused based on her gender. Her husband actually has to sue for her because she's not allowed because she's a woman. And her case does go up to the U.S. Supreme Court on that 14th Amendment argument. What does the court say, though? They say that citizenship didn't give women the right to vote. They actually say, and I kind of paraphrased it, but they said, of course you are a person and a citizen, but so are children. And who would suggest that children have the right to vote? Again, not a very attractive comparison for full-grown women. So the movement's progress from this point is really slow until the 20th century. And the reason being is because the legal avenues have been closed at this point. So there's 2 options left. They're going to go a state by state or federal amendment push. Those are really the 2 options. And the women's movement splits at one point in the 20th century. And the first one is and I apologize, there's a typo, but it's the NAW, the National American Women Suffrage Association. That new generation of women will under the NAWSA title have a more conservative approach. They'll look at the state by state suffrage approach. So there's a new generation of women working outside the home, going to school, working in factories. So life is changing. Things for women are changing as far as where they're not just going to be in the home anymore. They're going to be out working and contributing to the community more. And Carrie Chapman Catt really is an important figure in this particular organization. She is someone who is great at organizing. You can see there are 7,000 to 2 million members. By 1920, it'll be the largest voluntary organization in the nation. She works on lobbying. She works on media with the news and pamphlets, and later with helping with parades and things like that. So she's kind of a dynamo when it comes to organizing. But one of the key things she does is when Woodrow Wilson is in office, she lobbies President Woodrow Wilson. And she says, look, we're going to support the World War I war effort. And later she'll talk about supporting him in the League of Nations, which he wants to get done after World War I. And he'll remember that. He'll say he'll kind of pay her back later, as we'll see on the next slide. Just as an aside, the NAWSA is now the League of Women Voters, which most of you may be familiar with. On the other side, you have Carrie Catt with the more conservative approach, and then on this particular slide, you have the National Women's Party with a more radical approach. They think that the other group isn't moving fast enough. The state-by-state approach isn't going to work. They want a federal amendment. And this is led by Alice Paul and Lucy Byrne. They were influenced by the British suffrage movement, which is a lot more radical. I mentioned the Pankhursts, if you get a chance to look them up. They were a lot more radical than the Americans will ever be in getting women's suffrage. But their big thing is marches, demonstrations, lobbying, grassroots organization, and really a media approach as well. They want to get people's let everybody see what's happening. You can see some of the pictures there with what's going on, not just talk to people, but show them. And finally, on the next slide, I wanted to show you a map of 1919, because the 19th Amendment will pass in 1920, but this is their map. So you can see that the West was more progressive in passage to date. So most of the West at this point is going to have full suffrage. But you look at the South, and the roadblock in the South, I'm going to sum it up to states' rights issues and racial tension, basically bias against race. And the East, why is it so difficult? A lot of that is due to corporate lobbying and big power players in the corporate area and in Congress not wanting to change the power balance. So I just wanted you to get a good look at the map before we get the actual 1920s. All right, so 1918, President Wilson announces his support for the amendment the evening before a vote's taken in the House. This is not the first time that the amendment will try to be pushed through the House and Senate, but it's kind of right at the end when it finally goes through. So in 1918, there is a push. 1919, finally, the House and Senate both passed by 2/3 majority, which is the required number that you have to get a amendment through the Congress for constitutional passage, and then it has to go be ratified by all the states, and you need 3/4 of the states. So that's going to be 36 in 1920, and Tennessee is the last state to ratify. And I love the story about Tennessee. It passes by one vote. I believe his name is Harry Byrne, basically gets a letter from his mom just before the passage that says, be a good boy and vote for suffrage. And he says every good boy should listen to his mother, and he votes, and literally his vote pushes it through. Without him, it wouldn't have been ratified. August 26, 1920, the amendment does have to go to the Secretary of State to be certified that everything has been done properly, and that makes it official and part of the Constitution. And you can see the amendment there. It's one sentence. It's in blue written there, and it took 72 years and 3 generations again. But I wanted to kind of end with this because I always kind of think, if you're looking at it from a constitutional perspective, was that it? And the answer is no. You'll see, as I believe the other speakers are going to show you, that for minority groups and up through 1965 and even to today, civil rights issues are going to be a big fight. So in 1971, we have Reed versus Reed. This is the first time since the 19th Amendment went into effect that the court will use that 14th Amendment equal protection clause to strike down a state law as unconstitutional because it used sex discrimination. And the case was brought on inheritance rights. It's not a super exciting case, but I think to kind of tie it up, one of the attorneys in the principal brief writers was a volunteer attorney from the ACLU at the time. Her name was Ruth Bader Ginsburg, one of our current Supreme Court justices. And I love what she says about it. She says in an interview that the 19th improves the 14th Amendment, and that women should, under the 14th Amendment's equal protection clause, be considered full persons and have all the rights of full persons under our democracy. And the last thing she says is, when asked about the change, why now? And she said simply this: the court switched because society had changed. And I think that this is true of many social justice movements. They rarely move fast. It's a lot harder than you think. There's a lot of hard work by regular people, and also society has to shift in their thinking as well. So I hope you enjoyed the path from Seneca Falls to the 19th Amendment.
Thank you, Professor Cox. And just as a reminder to the students, if you have questions, put them in the chat. I'm collecting them, and then I'll ask our speakers at the end. But now I'm going to hand this over to Professor Pointer Adderley.
Thank you. And hi, everyone. So again, Rebekah Pointer Adderley. I'm going to talk about some of the early civil rights movements and start around 1920. Let's see. So first, just kind of a recap and um, summary of what's going on. World War I, women were working in factories, supporting war efforts. There was an increase in activism. They wanted to advance suffrage. Other important issues were workplace fairness and safety and abolishing child labor. Contraceptive usage led to more sexual freedom and less restricting social norms and attitudes about women. One interesting thing about this, when you talk about rhetoric and activism, a lot of the times you will see fashion trends kind of change to send messaging. And so, with this relaxation in the social norms and attitudes about women and sexual freedom, there were some changes in fashion trends that align with that as well. And then we had, of course, some women were granted the right to vote. And so what else is going on? So you have the National Women's Party. They proposed the first equal rights amendments to address gender discrimination. You had African American club women who played a very important role in advocating for women's rights. Um, you had pushed for civil rights and equality for African Americans. That you had the beginning of the Black nationalist and Pan-African nationalist movements. And then you had the economic depression and the rekindling of racist movements. So first, I want to talk a little bit about Alice Paul, and she was referenced earlier. A quote that she made in 1920. She stated that it is incredible to me that any woman should consider the fight for full equality won. It has just begun. So she was head of the National Women's Party. She and other suffragists picketed the White House for 18 months. And it was interesting when I was reading about this because initially, when they were doing the picketing, the president was kind of just like, oh, he'd walk by and tip his hat and he's kind of, think whatever. But after the war started and they continued, some people thought it was unpatriotic for them to continue to protest during the war. And they were eventually jailed for obstructing traffic, air quotes, for 7 months. And there was actually a movie called Iron Jawed Angels that came out to depict this time period. And they were thrown in prison and they were beaten and thrown in cold, rat-infested cells. They noticed that they were being treated worse than actual murderers and hardened criminals. And so they staged a hunger strike and they were forcibly fed. And the prison officials were really trying to have Paul declared insane so that she'd be sent to a mental asylum. And so, again, the movie Iron Jawed Angels, I have not seen it, but from what I hear, it's a pretty good depiction of what happened during that time. And afterward, Paul and the National Women's Party focused on equal rights and the Equal Rights Amendment to guarantee women constitutional protection from discrimination. This was, of course, after she got out of prison. And she spent her life advocating for the ERA and other women's issues. She began working on a new constitutional amendment in 1923 called the Lucretia Mott Amendment. And this called for absolute equality and stated that men and women shall have equal rights throughout the United States and every place subject to its jurisdiction. And the Equal Rights Amendment was introduced in every session of Congress from 1923 until it passed in 1972. And that is a long time. So, how did the National Women's Party address the enfranchisement of African American women? And we have a picture of Ida B. Wells here. And so, Southern states mostly opposed voting rights for Black women. And even though in the North it was a more popular idea, some Northern suffragists feared that including Black women in the push for voting rights could cost much needed Southern votes. And so Alice Paul kind of straddled the fence. She seemed to privately support suffrage for Black women, but publicly she had some contradictory statements and kind of distanced herself from it. So here's the tea. And if you follow pop culture, the tea, like the gossip, here's the tea. We're going to spill a little bit of tea, give a little background. So the march in 1913, Paul actually had invited Black women, suffragist activists, the women of Delta Sigma Theta Sorority Incorporated, to participate in the march. But there was a lot of criticism that she received from some of the Southern suffragists, and they were like, we're going to pull out. If you let them come, we are out. And so then she reconsidered and she was like, well, we don't really want the march to be complicated with racial issues. So Ida B. Wells, the lady who was pictured in the previous slide, Ida B. Wells was initially asked, after she was invited, she was like, well, can you not march alongside the Illinois delegation? Can you go march in the back with the Black delegation? And she said, no, if I'm going to participate, I'm going to march with my delegation from my state. And there was a little bit of drama that ensued, but eventually she was allowed to march, and she had two white allies, supporters, marching alongside of her to show support for her being there. And another interesting fact, Paul once told a reporter that all this talk of Negro women voting in South Carolina was nonsense. But then she later stated, while talking to someone from the NAACP, that she didn't remember making this statement. And then she also said, I don't see how anyone could think that that statement was unfair to colored people. And so, there was no Twitter or social media back then, but the National Women's Party papers in the Library of Congress, they actually have letters that you can see where people were writing during this time period, letters that were written to Paul or about these situations. And so basically, it was a complicated situation. Many suffragists felt like the inclusion of African American women would ultimately harm the cause, and many Southerners were opposed to it because they needed every vote they could get. And again, they wanted to kind of keep women's issues at the forefront and leave racial issues out of it. But the Black suffragists did have some allies. For example, Harriet Stanton Blanche, Elizabeth Stanton's daughter, she lobbied for the inclusion of African American women in the National Women's Party platform in 1920. And that Library of Congress Historical Women's Party papers that I referenced earlier, she actually had written a letter, and her letter is stored there. And so all in all, these issues highlight the need for intersectionality within feminist movements, because again, the push was for women's votes, but women means all women and not some women. And so voter suppression was running rampant during that time period, and there were several things that happened that made it very difficult for women of color and Black voters in general, but especially women, to vote. So you had poll taxes that were nearly impossible for poor families to pay. If you couldn't afford the poll tax, you couldn't vote. You also had police intimidation. You had voters of color who were routinely harassed and subjected to false arrest, intimidation. You had economic retaliation. So if someone voted, they would be, coincidentally evicted from their home or fired from their job, or they'd have foreclosure, or they tried to go to the bank and get a loan, they'd be denied. And then, of course, you had the domestic terrorism. You had KKK activities, lynchings, beatings, rapes, burning people's homes down, burning crosses in people's yards. So there were a lot of things that were happening that made it very difficult for people of color, especially women of color, to vote during that time. And so the next woman I'll talk about briefly, Mary McLeod Bethune. She was an educator, an organizer, and political activist. And she opened the first school for African American girls, which is now known as Bethune-Cookman College, which is a very prominent HBCU. She actually raised money to cover poll taxes for 100 voters in Florida. She taught women how to pass literacy tests. And during the Roosevelt administration, she served as the program director for the Division of Negro Affairs. And so the last woman I'll reference briefly is Frances Perkins, and she is known as the woman behind the New Deal. She was appointed Secretary of Labor under President Roosevelt in 1933. She was the first female cabinet member that we've ever had in this country. And she was responsible for minimum wage, work hour limitations, and the Social Security Act. She also wanted university health care, which is interesting. She was before her time. And so here's a few fun facts about Perkins. She purposefully dressed in an understated fashion. Again, remember I said a lot of times women's movements and activism were aligned with fashion choices. She never wore makeup. She preferred no nonsense black or navy suits. And she kept notes on her male colleagues in a red envelope entitled Notes on the Male Mind. So she noted that men were more receptive to women if they reminded them of their mothers, which is really weird. But this impacted her wardrobe choices. And she would sit in the back during the cabinet meetings and she wouldn't speak until she was called on by the president. But while she was sitting in the back, she was just observing the men and taking notes. And this was a really great persuasive strategy that helped her to advance her ideas. So that sums up 1920s through 1945. And now I'm going to turn it over to Kenya Wilson for a continued journey through women's rights 1940 through 1960.
Thank you so much, Rebekah, and the other presenters for allowing me to be here today. So let me see if I can, where did the presentation go? Do I need to upload it on my own?
I have to remember how to open it again. I'm so sorry.
Say that again, Misty.
I'm trying to re-upload it for you. I'm sorry.
It's okay. I see it moving. Okay. Then I'll take control. Okay. Are we ready?
Yes, ma'am.
Okay. Gotcha. Thank you so much. Okay, I'm going to talk about briefly the continued journey for women's rights and the influence of women on the Constitution, the Civil Rights Movement, and a bit of the legislative and judicial branches during the 1940s and the early 1960s. I'm going to mention monumental events that served as catalysts for legislature for women's and civil rights, and also a few monumental women who influenced change during this period. So the first thing I will start with is the effort which served as a catalyst to end the practice of paying women less than men for the same work. In 1945, U.S. Congress introduced the Women's Equal Pay Act, which would have made it illegal to pay women less than men for work of comparable quality and quantity. Equal pay legislation that would apply to the private sector workforce was introduced in 1945 with the Equal Pay Bill of 1945. The then Secretary of Labor Schwellenbach spoke out in support of the bill, basically saying that he saw no basis for making a distinction between men and women workers in this connection. If they turn out the same quantity and quality of work, they should receive the same compensation. However, this measure failed to pass, but despite of campaigns by women groups, little progress was made on pay equity during the 1940s and 1950s. And by 1960, women still earned less than 2/3 of what their male counterparts made. And this was a continuous struggle, and we'll talk about when that came to a head a bit later in my section. So one thing in one case that I found that was interesting that influenced the Constitution under the 14th Amendment was the case Goazart versus Cleary. So the long fight for women's rights spilled over in many different societal issues and areas of life that affected women. So this case basically talks about women influencing social norms and in the areas of, social, what was normal socially, and entrepreneurship. In the Supreme Court case in 1948 with Gozart versus Cleary, it basically addressed a Michigan statute that required all bartenders to hold licenses in cities with populations greater than 50,000 people. But the statute also stated that a woman could not be issued a license unless she was the wife or the daughter of a male owner of a liquor establishment. Valentine Gozart was the owner of a bar in the city of Dearborn, Michigan. And according to that Michigan law, she wasn't allowed to be the owner because the population of Dearborn exceeded 50,000. In November of 1947, she and her daughter challenged the Michigan law at the District Court of Detroit before Circuit Judge Simmons and District Judges Levine and Pickard. They were represented by attorney Ann Davidow. Ann became the first woman attorney to make the argument that sex discrimination violated women's constitutional rights, denying them equal protection and treatment as outlined in the 14th Amendment. And she also dedicated to her career as being a lifelong feminist and women's rights activist. She argued in the trial that the law denied the women equal protection of the laws and deprived them of their property without due process of the law. It was interesting to learn in this case that women could still work as waitresses serving drinks. However, they were not allowed ownership of bars under the pretense that it would protect them. Serving drinks to customers would protect them from the dangers of immorality that was apparently an integral danger serving drinks from behind the bar, which I felt was interesting. And you'll find that a lot of constitutional law regarding women's rights kind of were based in the idea that women were inferior and just needed this protection from immorality. However, they were often put in situations that exposed them to just that. So after that, a 3-judge panel of the U.S. District Court of Eastern Michigan rejected the bartender's claim. In a 6-3 opinion authored by Justice Felix Frankfurter, the court concluded that the Constitution does not preclude the states from drawing a sharp line between the sexes or to reflect sociological insight or shifting social standards any more than it requires them to keep abreast of the latest scientific standards. So the Supreme Court validated the Michigan's Bartending Act because it was rationalized that since women do not have any federal right to work in any occupation that they choose, that the law was not discriminatory. Even though Gosard and Davidow lost in this trial, the barmaids still fought for change, and women kept the law on their minds of their legislators through continuous shaking and mixing. Get it? Change wouldn't be finalized regarding this matter until the law was repealed in 1955, bringing a huge victory for female bar owners and barmaids because with these laws came changes in ways that society viewed bartending and other work as men's positions. So the next thing I want to talk about briefly that happened during this time period in the 40s is the women's right to serve on juries. So although most women were provided the right to vote in 1920, many women in states across the U.S. still struggled to become fully recognized citizens. An example of these struggles manifested through their efforts to gain a right to sit on juries. While some state campaigns for women's rights to serve were easy, there were some that proved to be difficult. And one example was North Carolina, who didn't receive a constitutional amendment to make women eligible to serve on a jury until 1945. This fight continued throughout the 60s, as evidenced by the case Hoyt versus Florida. The Supreme Court heard this case, challenging a conviction based on the fact that the female defendant faced an all-male jury because jury duty was not mandatory for women. The Supreme Court denied that state statute exempting women from jury duty, saying that it was not discriminatory, finding again that women needed protection from the atmosphere of the courtroom and that it was reasonable to assume that women were needed in the home. Although the Civil Rights Act of 1957 actually gave women the rights to serve on a federal jury, it was not until the mid-70s that all states passed similar legislation. And it was interesting to read about and learn about the landmark case that kind of drove that. And it was a case in 1975 by Taylor versus the state of Louisiana, driven by a man named Billy Taylor, who was found guilty of kidnapping and challenged his own conviction due to the fact that no women were allowed on a jury. And they allowed him a retrial, and then that law was repealed in all 50 states. So although it wasn't a woman who ended up making the change solidified, women were still a part of that fight to make sure that they were able to serve on juries. I wanted to mention briefly in the 1940s, in that time period, because that's where I still am, Bernita Shelton Matthews, who was appointed by President Harry Truman to serve on the U.S. Court for the District of Columbia, making her the first woman to serve as a federal district court judge. Throughout her career, she was met with resistance, rejected by male professional lawyers associations and the District of Columbia Bar Association returned her application and checked for dues. So because of that, Matthews and other women formed their own professional associations, including the Women's Bar Association of the District of Columbia and the National Association of Women Lawyers. I also wanted to talk about something that happened in this time period in the 1950s, which is a notable case, Brown versus the Board of Education, which many people are familiar with. And so when you think of Brown, it is important that we remember the companion cases and the girls who were involved in the fight for justice leading to desegregation. These cases are Belton versus Gebhardt and Davis versus Prince Edwards County. And all of these are, I think, 2 of 6 companion cases that led up to the resolution in Brown versus Board of Education of Topeka. So we'll talk a bit about the Belton versus Gebhardt case. Ethel Brown was born with a heart condition, but because she was Black, she had no choice but to travel 2 miles every day to attend Howard High School, the only public high school in the state of Delaware that admitted Black students in 1950. Her mom was concerned about Ethel's ability to make the trip and petitioned the school board to allow Ethel to attend the nearby Claymont High School, which was only reserved for white students. Her request was denied. And despite Ethel's status as a young girl with a severe medical condition, she was treated as unworthy of any protection or equal education because of her race. So because of that, her mother, Mrs. Brown, joined a group of Black parents bringing the lawsuit Belton versus Gebhardt. And I wanted to include that and talk about that in great detail because when we think about Brown versus BOE, we kind of forget the forerunners before that really led up and supported that resolution by the Supreme Court. And we know Brown versus BOE of Topeka was a landmark Supreme Court case in which the justices ruled unanimously that racial segregation of children in public schools was unconstitutional. When we think about civil rights, we talk about Rosa Parks quite a bit. And the reason why I included her here is because really this monumental moment in the history of civil rights was kind of a push towards the civil rights movement, as well as the right to vote and ending voting discrimination for African Americans. So in 1955, of course, an African American seamstress galvanized the U.S. Civil rights movement by performing an act of civil disobedience and refusing to yield her seat to a white man and move to the back of the bus in Montgomery, Alabama. This again was one of the catalysts that sparked the civil rights movement and led to the right to vote for African Americans, leading to leading to the vote, the Voting Rights Act, of 1965, which allowed African Americans and ended voter discrimination. So let me continue. So that act again acted to enforce the 15th Amendment to the Constitution, signed into law 95 years after the amendment was ratified. In those years, African Americans in the South faced tremendous obstacles to voting, including poll taxes, literacy tests, and other bureaucratic restrictions to deny them their right to vote. They also risk harassment, intimidation, economic reprisal, and physical violence when they tried to register. As a result, very few African Americans were registered voters, and they had very little, if any, political power, either locally or nationally. And it wasn't until after that act was enforced that the increase of African American voters were present. Alrighty. I also wanted to mention Charlotta Spears Bass, who was the first Black woman nominee for Vice President in the United States. And she ran on the Progressive Party ticket, which received less than 1% of the popular vote in the 1952 presidential election. She was an American editor and civil rights activist whose long career was devoted aggressively to publicizing and combating racial inequality. Next, I'm going to mention Patsy Takimoto Mink, who was born in Paia, Hawaii in 1927, and she was the first woman of color of Asian Pacific Islander descent to serve in Congress. And she devoted her career in the 60s to the Great Society legislation during the first phase of her congressional career. As a veteran politician, she began to have significant impact on the nation during both of her stints in the U.S. House of Representatives, and her legislative approach was marked by her belief that the representation extended beyond one's borders of congressional districts. She was said to, quote, "You are not elected to Congress, in my interpretation of things, to represent your district, period." She noted that you are national legislators to her peers. I also wanted to mention the Equal Pay Act of 1963 that was passed by Congress, promising equitable wages for the same work, regardless of race, color, religion, national origin, or sex of the worker. Calls for federal equal pay were pushed in the early 1960s during the administration of President John F. Kennedy. Esther Peterson, the head of the Women's Bureau of Department of Labor, was a vocal supporter of the proposed legislation, as was former First Lady Eleanor Roosevelt, who chaired Kennedy's Presidential Commission on the Status of Women. Representatives Catherine St. George and Edith Green helped lead the charge for a bill of Congress. Despite the opposition of powerful business groups such as the Chamber of Commerce and the Retail Merchants Association, Congress passed the Equal Pay Act in 1963 as an amendment to the Fair Labor Standards Act in 1938. In its final form, the Equal Pay Act mandates that employers cannot award unequal wages or benefits to men and women working jobs that require equal skill, effort, responsibility, and which are performed under similar working conditions. I'll also mention the Title VII of the Civil Rights Act, which passed in 1964, prohibiting sex discrimination in employment, and the Equal Opportunity Commission was also created that year. And I want to highlight here in that movement Martha Griffiths, who was an American lawyer and judge and was one of the driving forces behind this act. Her mother's foresight and her paternal grandmother's struggle to raise 3 children when her husband died inspired Martha to pursue equal rights for women. She attended the University of Missouri at Columbia, earning an A.B. in political science in 1934. In 1964, she made one of her 2 greatest contributions to the women's rights movement as the House Judiciary Committee began to deliberate a landmark civil rights bill pertaining to racial discrimination. She argued that sexual discrimination must be added to it. She did much to frame the Sex Discrimination Amendment to Title VII of the Civil Rights Act, and later prompted the new Equal Employment Opportunity Commission to enforce the act more vigorously. Though many of the Southern lawmakers who passed the amendment voted against the whole Civil Rights Act of 1964, the House and the Senate eventually passed the bill, and President Lyndon B. Johnson signed it into law later that year. And lastly, I'm going to end with fighting Shirley Chisholm, who was the first African-American Congresswoman. Shirley Chisholm represented a newly reappointed U.S. House district centered in Brooklyn, New York. She was elected in 1968 because of her roots in the Bedford-Stuyvesant neighborhood, and she catapulted into the national limelight by virtue of her race, gender, and outspoken personality. She represented the 12th District of New York and became the first Black woman elected to the U.S. House of Representatives in 1969. While in office, she fought for the same issues that she'd been passionate about as a community advocate: children's education and welfare, and a guaranteed minimum income to help the poor, immigration rights, and women's rights. And that concludes my portion of the presentation, and I will go ahead and pass it to Professor Allegra Davis.
Thank you, Kenya. So I'm gonna not go through all of my slides because I do want to leave time for questions, and because we've already talked a little bit about the 14th Amendment, but I do want to talk to you about women in the Supreme Court and what that has to do with the Constitution. And I'm gonna skip a little bit to just hit the highlights here. So the Constitution, of course, established and required the Supreme Court as the judicial branch of our government. And the court is responsible for interpreting the Constitution. So it's kind of the highest court in the country, obviously, and is the final decider of cases that have to do with the law. So they are kind of treated as the guardians and the interpreters of the Constitution. So they serve a really important role in the country and in regard to the law and the Constitution. And of course, they provide that check on the other 2 parts of government. I don't know what it's doing. It skipped a bunch of my slides. Okay. Sorry, I'm getting there. Okay. So members of the Supreme Court are appointed by the president and approved by the Senate. And I'm sure many of us have seen Senate confirmation hearings for Supreme Court justices before. And they generally serve life terms. Of course, they are allowed to retire, but they don't have to get reappointed or reelected at any time. And they do that to keep the judges from being pressured by the changing political atmosphere of the country. So they just want them to have a lifetime appointment and not have to worry about appealing to the masses in the future. And they also have a set salary that can't go down while they serve in office. I don't know what their salary is, but we've had a lot of Supreme Court justices since the court was formed in 1790. And this is the first Chief Justice. His name was John Jay. And this is the current Chief Justice. His name is John Roberts. So we've had in our nation's history 114 Supreme Court justices in total. Of those 114, 4 have been women, 3 have been people of color, and 19 states have never produced a Supreme Court justice. So there are a lot of questions about equity and equal representation on the Supreme Court. And here are the only 4 women who have ever served on the Supreme Court, all taking a picture together. 3 of these women are on the Supreme Court now, and one is Sandra Day O'Connor, who retired from the Supreme Court in 2006. So you can see that the other 3 are very recent additions to the Supreme Court. So the Supreme Court has taken a lot of cases that have to do with gender and equality under the law, and my colleagues have talked about a lot of those cases previously. Some of them are not really shining moments in the history of the Supreme Court. One such case is Mueller versus Oregon, and it basically upheld a law in Oregon that limited women to working no more than 10 hours a day. And the brief written for that case had a lot of quote unquote data about how long working hours for women negatively affected their health, safety, and morals. So that's not a great moment in Supreme Court history. And this is what the court looked like that decided that case. You'll notice that all of those people have a few things in common. And the 14th Amendment has several sections, but the first section is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. So it's a citizenship amendment in some ways, but there are these very important clauses, including a due process clause that says that no state shall deprive any person of life, liberty, or property without due process. And the Equal Protection Clause, it says people can't be denied equal protection under the law. And those 2 clauses turn out to be very, very important in a lot of Supreme Court cases. And I'm not going to step us through all of them. They're in the slides, and we can share those slides with you if you'd like to see them. But one is Griswold versus Connecticut, and that was the Supreme Court ruling that married couples were allowed to buy and use contraception without the government restricting that purchase or the use of thereof. And so they really derived that right to privacy from the 14th Amendment. And here's that court that decided that. Yes, it was only married couples. And in 1972, unmarried couples secured the right to contraception, and they used that Equal Protection Clause to say if married individuals can access contraception, then unmarried individuals should be allowed to do the same thing. 1972 seems very late to me. This also led to Roe v. Wade. We're just, again, extending the clauses from the 14th Amendment. I mean, we're extending the privileges seen from the 14th Amendment. And those same ideas about privacy and due process and equal protection under the law extended eventually to allowing contraception for younger and single individuals, and eventually to legalizing same-sex marriage. And this is the court in the Oberfeld decision that legalized same-sex marriage just a few years ago. So I'm going to stop there so that we have a great 3 minutes for questions, Misty.
Fantastic. So my first question that I have is for Professor Cox. Can you tell us geographically where we saw the most support for suffrage? Was it the East Coast, West Coast, or the South?
It's actually on the West Coast. So the map, I know that the question said where it's blacked out. That was actually where no suffrage was. So Wyoming is the first state in 1869 to allow suffrage, and their reasoning is basically the same as the rest of the West, is they need women. I think at the time that Wyoming grants women's suffrage, full suffrage, there are 6 men to every 1 woman, if that makes sense. It's about that ratio, and it's like that in most of the West. These are territories. They're new, and also I think it has to do with the frontier life. There's a lot of stories about women being more equal partners in work on the frontier. So definitely the West is where the map that I showed you, and I'll put the link for the map here in a second, but the victory map showed the West is all kind of white or cream colored in the old map. That's where most of the suffrage was granted first. In the South and East Coast, definitely not.
Thank you. For Professor Pointer Adderley, when you talked about some women having the right to vote, how do we determine who the some women are?
Yes, so great question. So the right to vote for women, it wasn't explicitly stated, no, Black women can't vote, but because of systemic oppression and the voter suppression tactics that were discussed, overwhelmingly Black women were barred from voting. Again, you had to think about the domestic terrorism. Were you going to risk retaliation from the KKK, your house being burned down, you know, any kind of economic backfire that you got for voting? The poll tax was also a determining factor because economically, if you didn't have the money or the means to pay extra to vote, you're probably not going to vote. And so it wasn't until the 1965, the civil rights legislation that did away with all of that, that cleared the way for people to be able to vote without so many obstructions. Now, there's still a lot of voter suppression that exists, and we'll actually be talking about that on the 22nd, I believe. So please tune into that one. But, when they say women received the right to vote in 1920, the women, it's really some women, it's not all women, because all women were not going to be, threatened or lynched or have their houses burned down. But specifically, those things were done to suppress the Black vote. So yes, voter suppression definitely was a huge factor. And again, a lot of that stuff has changed. And it's interesting because some of the information that I saw about how they did voting, it would vary by state to state, but the person who was in charge of that, of the voting setup, they could make up their own rules in many cases. So they could say, oh, you have to meet this criteria to register. But then if they saw someone Black come in, it was very common that they'd make up some different criteria that just kind of made it impossible altogether. So it's really important. Every year around this time, we always see, oh, it's the, women's suffrage and, women got the right to vote. But it's very important that it was not all women. It was some women. And thankfully, the activism and the civil rights groups continue to push. But we do still have a lot of work to do in terms of voter suppression because it unfortunately still exists today.
For Professor Wilson, when you were talking about the bar owner, can you tell us, if you know, did she inherit the bar or did she actually purchase it outright herself?
That is a great question. And most of the cases that discuss, or the sources that discuss the particular court case, do not make that distinction. They do make the distinction that that there's a classification between wives and daughters of liquor establishment owners, but it does not say if her husband owned the bar or not, or her father for that matter. It just says she was, most of them say that she was the bar owner. That's a good question.
Thank you. And something when you and Professor Cox were talking that occurred to me, you were saying that women have to be protected from this immorality that's in the world. And yet, Professor Cox, you were talking about women almost being treated like children, like they're this not quite fully developed class of individuals. I think that's a really interesting kind of paradigm there because we also talk about women as being the keepers of morality. So it's interesting that we see arguments made from both sides there.
Absolutely.
Yeah, and I think it's interesting too because you look at the inheritance case that I mentioned, the very last one, the Reed case, which was 1971. In that case, the son had passed away, and the mother and father were divorced, and basically the court said the man gets everything. You're a woman, you don't need it. And that was 1971. So even as everybody's kind of talked about, this persisted for such a long time, and I think that's really important to know.
Yeah, it can kind of sometimes feel like ancient history, but it's really not. All right, so to all of our students, thank you so much for attending. We're really appreciative that you're here. I am going to put that link into the chat for you, so you can click on that. That is how you will get attendance credit, and we will send out something to your professors that lets them know that you were here. There's a couple of questions you need to answer. We'll also get the recording out to anybody that would like to have it. So thank you all to our presenters. Thank you to students for showing up. And I hope that everyone will be joining us next Tuesday for National Voter Registration Day.